Welcome back, and we delve into some crucial issues this morning. The fate of 4 members of Parliament hangs in the balance as Speaker of Parliament Alban Sumana Kingsford Bagbing has ruled declaring their seats vacant, or he has to rule on that to declare it vacant or not in the next 48 hours. Now, this follows a petition by the former Minority Leader Haruna Iddrisu to the Speaker that their seats be declared vacant, invoking Articles 97(1)(g) of the Constitution. But Majority Leader Alexander Apenyo-Markin has taken matters into maybe his own hands by pushing for the Apex Court to make a pronouncement on this all-important matter. Because guess what? In the end, there are 4 of them involved, 1 of them from the NDC's end, and 3 of them tied to the MPP, which means that that could shift the majority position in Parliament before election 2024. So, where do we go from here? I want you to watch this footage of what happened in Parliament yesterday, and then we'll come into the studio with our guests.
Speaker, Parliament hasn't yet taken a decision. In fact, in the context of Article 2 of the Constitution, it is an act or omission of a person which violates the Constitution, which triggers an action before the Supreme Court for either an interpretation or an enforcement of the Constitution. Mr. Speaker, the Majority Leader knows that to take an action in anticipation does not comply with the letter and spirit of the Constitution. In fact, the Supreme Court made it very clear in Akufo-Addo and Attorney General that it does not give advisory opinions. What the Majority Leader has done is basically asking the Supreme Court to give an advisory opinion on a matter that, in respect of which Parliament hasn't yet taken any action. And as a Leader of the House, I think that what he's doing, or what he has done by taking that action, is basically weakening the power of Parliament. It was in the same Akufo and Attorney General that the court said that whatever happens in Parliament is a closed book.
I'll read that. It says, when a member makes a statement, the Speaker, considering the comments of the statement, may direct a committee to investigate and inquire into the matter. And the last part says, and when necessary, propose legislation. But this is not about legislation. So, Mr. Speaker, a statement is made. First of all, the statement has to be admitted. But because of the urgency of this matter, I don't think I'll even belabor that point. Order 93.8 says that the clerk shall make available to members copies of the admitted statements. But because of the urgency of this matter and the seriousness of the matter, I will not also belabor that point. But Mr. Speaker, when you look at Order 3, Order 3 says that, Order 5, 2. They say in any case not provided by these orders, the Speaker shall decide on the posterior question. Mr. Speaker, as far as Order 93 is concerned, it is clear what will happen to a statement made under Order 93. And we have been in this house for a long time. When you decide to make a statement, after people will comment, that's what we are doing. When we finish commenting, if the Speaker thinks that the comments are such as to raise a serious issue, you refer the matter to a committee. The committee will go investigate the matter and bring its report. Mr. Speaker, the question of how to enter into Parliament in a particular matter lies entirely in the bosom of the person who intends to bring the matter to Parliament.
So there you have it. Those who will be joining us on this belt of the conversation as we get into the legal intricacies, including the parliamentary decision-making process. Roxanne Nelson Dafiamekpo, he will be joining us shortly. We have Kweku Paintsel, a lawyer. We have Dr. Rashid Draman of the African Center for Parliamentary Affairs, and John Osai-Kwapong, Dr. John Osai-Kwapong, a CDD fellow. Gentlemen, good morning.
Good morning. Good morning.
Okay, so, all right, I see you, Dr. John Osai-Kwapong, and I see Kweku Paintsel. Roxanne Nelson Dafiamakbo is on phone. Very good morning to you, Roxanne. I'm trying to connect with the South Dine legislator. Roxanne, if you can hear me,
Hello.
Good morning to you.
Hello, good morning.
Okay, you sound a bit low. If you could just speak
Hello,
up.
good morning.
Good to hear from you.
Good morning to you, good morning to my co-family.
Right. Thank you, Kweku, for joining. Thank you, Roxanne, and thank you, Dr. John Osai-Kwapong. I'd like to pick your initial thoughts before we kickstart the investigation or the conversation proper. Your quick thoughts on these developments and what you make of it on the surface. I'll start with you, Kweku Painter.
Hello?
Yes, Mr. Painter, I can hear you. Go.
Yeah, you can hear me?
Yes, I can. Go ahead.
Excuse me, what's your question?
So I'm asking, on the back of what happened in Parliament yesterday, before we get into the nitty-gritty, your brief assessment in less than a minute of what you saw and what you think about the happenings.
Well, that's normal business. Parliament would always stand on opposite sides of the same issue and argue, and therefore it's not really strange. They are divided upon a matter which they both believe in their side. So it's normal. That's how Parliament operates. Even when the law is so certain and so clear, parties will always disagree. And therefore, I find that it's strange what happened yesterday. That's my brief assessment.
Thank you. Roxanne, you were in Parliament. What do you make of these developments, especially with the former minority leader and what he has brought to the fore on this matter?
Now, thank you very much. I wasn't just in Parliament, I also contributed towards the statement made by the minority leader. Now, regarding the notice of petition brought by the former minority leader, that is a process that's pending. But in review of the matter raised yesterday by the minority leader, it's germane. Germane in the sense that there's no way the issues contemplated under Article 97.1 of the Constitution in such a way that in terms that any of such an instance is triggered, it can be ignored. What are we saying? We are saying that, for instance, as a member of Parliament, you vacate your seat when Parliament is dissolved. It is that simple. There's no litigation about that. And that you resign when you vacate your seat when you resign. It is that simple. There's no litigation about that. When, as a member of Parliament, you are elected to serve as Speaker, you vacate your seat. There's no litigation about that. So all the instances cited under Article 97.1 of the Constitution, there are no litigation. The point we are making is that when an independent member of Parliament decides to join a political party, he has to vacate his seat. Where a member of Parliament or the ticket of a political party decides to conduct his business as an independent member of Parliament, you have to vacate your seat. It is that simple. These matters have not been disputed. So the automaticity of operation of law is what we are calling to be enforced, and that's our point. And this matter, Professor Okwe, as the then Speaker in November 2010, had the opportunity to pronounce on it. And it's a precedent. So we are only following precedent, or we are only asking for the precedent to be followed.
All right, that's and all. There has been no swaying from this precedent in the past?
At all. It's not been disputed. It remains the position of the House. It's not been litigated in court either.
Right. And we'll get to, I mean, those honorable advocates, for example, saying that this is premature, the majority leader going to, that it could tie the hands of Parliament moving forward. Atachia saying that, you know, these people have the right to think and decide whichever way they want to go. We'll get into all of that. If you look at Article 97.1G of the Constitution, and 97.1 from A onwards talk about a member of Parliament vacating his seat, his here used in generic terms, in Parliament, and the conditionalities. G says if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent member. And it goes on and on from there. Or H, if he was elected a member of Parliament as an independent candidate and joins a political party, which would be the case of Honorable Esiama, for example, the second Deputy Speaker. But let me come to you, Dr. John Osai-Kwapong. Quick thoughts.
It's an interesting development, and it will be very interesting to see how the Speaker rules on it. Following proceedings, he's asked for 48 hours to be able to come back with a well-reasoned, well-informed, fair judgment, etc., etc. So it'll be very interesting to see whether he departs from the precedent that was set by the former Speaker of the House, Speaker Okwe, or whether he would reinforce that precedent. But you also cannot overlook the politics of it, which is control of the House is a stake, right? And that if you follow the precedent, this turns the House into the hands of the minority party, even if Parliament only has 3 months left in this parliamentary, the life of this particular Parliament. So it will just be very interesting to see how all of this, unfolds, especially also given the judicial aspect of it, which is will the courts, have a say in this, and what kind of say will the courts have, and how will that also affect the extent to which this issue is resolved.
Well,
Right.
now that we've laid the foundation, let's get into the critical issues.
I want to start with the Member of Parliament and lawyer, Roxy Nelson Dapemokbo. I want to find out from you, do you think, or what is your assessment of the political risk that this situation poses, both to the minority and the majority, before we proceed?
Thank you very much. But whether or not there are political ramifications to this matter is immaterial.
Is it material?
It's immaterial. What
How
is
so?
important is that, hold on. What is important is that what does the law say? And how was the law enforced the last time that we had a similar scenario? The last time we had a similar scenario was in October 2020, when the now second Deputy Speaker of Parliament, who was the then Member of Parliament for Mina on the ticket of the MPP, decided to abandon the political party that sponsored him to Parliament and to go independent. To go independent in the sense that as a sitting member of Parliament at the time, he decided to abandon his party. The party triggered the process by formally writing to Parliament for the enforcement of Article 97(1)(g) at the time. They wrote to Speaker on the 13th of October 2020. The Speaker came back on Saturday, 7th of November 2020, and made a pronouncement. In making that pronouncement, the Speaker declared that for forfeiting the membership of your party by going independent, you have automatically left the membership of your party, and by automaticity of operation of law, you are deemed to have vacated it in pursuance of Article 97(1)(d) of the Constitution. He painted a number of scenarios. He says that it is not in the contemplation of the Constitution to expect a member of Parliament or who sits on the ticket of a party to leave the party and pretend to do things politically independent and still be expected to champion the cause of the party in the same Parliament. That is not in the contemplation of the Constitution. So when that happens, it is a lacuna that the Constitution does not contemplate. Then we again ask, if in the course of going independent, the sitting member of Parliament wins the seat, and he returns to Parliament of the state Parliament to conduct business, how is he expected to, in the same breath, oppose the party that he previously was a member and also to canvass for his issues as an independent member. So these scenarios were clearly not contemplated and not approved by the Constitution. That is why the Constitution says, when you
your voice is fading away, as you go. Kindly speak up for us.
Okay. So that is why Michael Quinn said, when that happens, you are expected to vacate the seat for the proper things to be done. Now, when you go to CI 127, that is the Public Elections Regulation 2020, if you go to Regulation 14.1, under Regulation 14.1, after the filing of nominations of candidates for a public election, the Electoral Commission will have to assign colors and symbols. And what they do is that under Regulation 14.1a, where a candidate in a public election, especially parliamentary or presidential, is sponsored by a political party, that candidate is assigned the symbols and colors of that political party. As we speak, the second deputy speaker, who is also the sitting independent member of parliament for Pomina, has been posted as the MPP parliamentary candidate for Pomina with the colors and symbols of the MPP for the December 7, 2024 election. So clearly he has joined the MPP. Two, if you go to Regulation 15 of the same law, which is the CI 127, the Regulation 15 mandates the Electoral Commission to issue what we call notice of poll. And the notice of poll is to be gazetted. The content of the notice of poll is to indicate the persons who have duly filed and are contesting for the election in a particular constituency or electoral area. This notice of poll will indicate your political color or the symbol that for which you are signed or sponsored by, and also your position on the ballot. As we speak, the Electoral Commission has issued its notice of poll, clearly indicating that the MPP member of Parliament for Aguna West, for instance, and Suhun, for instance, have been given independent symbols.
Right.
They are no longer assigned. Yes.
Be that as it may, you say it's insignificant, but the majority leader has taken this to the Supreme Court. Do you still maintain that the Supreme Court's ruling will still be insignificant if these seats must be declared vacant by all means?
No, you said the political ramifications. I'm talking to the law. Okay. So in respect of the fact that the majority leader has gone to court, the Supreme Court in the Fiapepo versus Attorney General recently held that the court cannot reject Parliament for performing its constitutional and legislative duties. So that is settled. So the right to go to the Supreme Court to as it were, injunct Parliament for making a decision in this matter has already been pronounced upon by the Supreme Court. So Parliament's hands are not tied at all. Parliament has the power and duty and the law to proceed to act in this matter without having to abide by any outcome of the Supreme Court.
Roxanne, right, we want to move to our other guests, but a quick one. So you're saying that based on that precedent, what you are saying is that this was a sort of illegality going on in Parliament, right?
Yes.
It was illegal?
Yes.
But it has been allowed to go on this long. The question then is, why are you now? Why now? Why now to remedy the situation?
What is an illegality?
Hello?
What is an illegal? Perhaps I didn't get it.
I'm talking about 97(1)G and maybe H as well. With these candidates now, after everything that has been done, Honorable Isiama has caucused with the MPP for quite a while, though he came into Parliament as an independent candidate. When it gets to this period, right before elections...
Okay, there's a distinction between caucusing and joining.
I get that point. That is not the thrust of what I'm saying. What I'm saying is...
Hold on, let me explain. The Constitution allows an independent member of Parliament to caucus.
Roxanne, if you will allow me to land, you will get my point. I'm not saying caucusing is the problem. I'm saying why now? Is it because of the electoral processes that have led to now the EC coming out and, like you said, Honorable Isiama having the colors of the MPP, contesting on the ticket of the MPP? which is why it is relevant now that they recuse themselves from Parliament. Is that what you're saying?
What we are saying is that to caucus with a group of Parliament is lawful, constitutional. But to decide to contest on the ticket of the party, it is what is deemed unconstitutional.
Okay.
And you have to wait until the person makes the decision and formalizes it. That is by actually filing with the Electoral Commission as the MPP candidate for Komina.
Thank you, Roxanne.
You cannot raise the matter when it is not mature.
All right, Roxanne.
Now it is mature for us to raise it.
All right, thank you. Thank you for those points.
I want to find out from Kweku Pencil, who is a lawyer. I mean, if these seats are declared vacant, Ben will come to you on other aspects, but if these seats are declared vacant, what is the next legal or parliamentary step? How will this affect the composition of Parliament? And what are the potential consequences for the NDC and the NPP? Mr. Pencil, are you with us? I don't think we have Kweku Pencil.
Check to see whether we have Dr. Rashid Rahman. Do we have Rashid Rahman on the line? Okay. Dr. Rahman, I don't think you've had a bite of this yet. You actually focus on... All right, so it appears we don't have Dr. Rahman yet. We rather have...
Dr. John Osai-Kwapon?
Exactly.
Okay.
Doc, looking at what has happened, we had wanted to get Kweku Pencil's thoughts on the legal intricacies of this matter. But from where you sit, Roxanne says precedents point to the fact that this is normal procedure. There is nothing wrong with this. When you get to this point in the electoral process and there are candidates per 97(1)(g) and H, this is what applies. Do you find any problem with the timing?
I mean, we are what? So, I mean, I in principle, I can understand why the point will be raised that, look, we are just trying to, now that the notice of poll has been served and these candidates have formally declared that either they are running on the ticket on the MPP or they are running as independents, then the normal course has to follow where we invoke the Constitution and say that you are in breach of it, therefore these seats must be declared vacant, etc., etc. I'm no lawyer and I'm no constitutional expert, but the thing that I wonder about is this is their intention on how they want to serve, not in the current parliament, but in the next parliament. So for me, my layman understanding of it is, I ask myself, should you hold these actions against them within the current parliament, of which they have not said, I am no longer either an independent or an MPP in this parliament, but rather, this is how I intend to serve in an upcoming parliament. And that for me is how I look at it as someone who is not a constitutional expert or a legal expert. I would simply say that if I look at both the letter and the spirit of the law, I am not sure the drafters of the Constitution intended it to be for, to apply to situations in which it's dealing with how I want to serve in an upcoming parliament, as opposed to in the current parliament.
Dr. Osai-Kwapon, I want you to listen to this again from the Constitution and then answer me. It makes clear a member of parliament shall vacate his seat in parliament. I'm going to read G and H to you one more time for the last time. If he leaves the party of which he was a member at the time of his election to parliament to join another party or seeks to remain in parliament as an independent member. Or H, if he was elected a member of parliament as an independent candidate and joins a political party. Honorable Esiama came as an independent candidate. Now, he's contesting in the 2024 elections on the ticket of the MPP. And you look at some of the others, they entered as on the tickets of the MPP. And now some of them are going independent. Do you still stand on the same premise you said?
Yes, because this is in the in this parliament, they have not left the party for the purposes of conducting business in this parliament. At least that's how I am reading it. They are saying, look, for the next parliament, I want to return either as an MPP or as an independent candidate. And that is, for me, how I am reading it and saying, perhaps that should be the way we construe this whole idea of, the party that you came in and whether you left, and if that means that your seat is now vacant.
Okay, let's go to Kweku Penso. He's back online with us. And Mr. Penso, so from a legal standpoint, how should the Speaker really interpret this Article 97 Clause 1G in the current context? Should there be more clarity around it, considering that the Majority Leader is seeking the Supreme Court's ruling on it? Do we need more clarity on this?
I will put it this way. It's only the Supreme Court of Ghana that can provide clarity beyond question on any issue of law. And therefore, if in the previous constitution or in the previous parliamentary session, the Speaker made a ruling, that ruling cannot bind the Supreme Court. That is at best a reflection of the Speaker's view on the matters that transpired before that parliament. And therefore, we cannot even be bound by that decision as far as the Supreme Court is concerned. It's possible that Parliament may use it as a guide in whatever they do, but the true body that defines what the Constitution says and how it is interpreted is the Supreme Court. And I'm allowed to say that I agree wholly with the previous speaker. Law is resolved in many ways, but let me give you by parity of reasoning, by analogous reasoning. How the law has defined relationships. With respect, let me use even just the simple everyday matter of marriage. If people undertake a matrimonial, affiliation, and that is to say a monogamous marriage under our laws, the law is clear that until that marriage has been dissolved by a court of law, irrespective of how the parties conduct themselves, the law sees the marriage as subsistent. There could be the man living with another woman, having left his wife wherever, and that kind of thing. I'm telling you, if the man were to die and the court has to make a determination as to his marriage, whatever, the woman he left under the matrimonial ordinance and failed to dissolve it through a court of law is recognized as the wife. I just want to enhance what the doctor has said, because he caveated his own decision by saying that because he's not a lawyer. Master, let him understand that what he's speaking does not only make common sense, but it is also a matter of law. And please, because I'm a lawyer and because this matter is the court of law, we'll all be judged at the end of the day by the view that the Supreme Court will take on the substantive issue of the capacity of a parliamentarian who decides to do business in the term of that parliament and not outside the term of that parliament. My view and my interpretation, which may be judged when the Supreme Court eventually rules, is whether by mere reason of a declaration of intent to contest another party's ticket, that makes him a member of that party for the current term that is in parliament. And besides, we are all forgetting the fact that the man represents a constituency. He represents people whose views and wishes and hopes and aspirations are hinged to his presence in parliament.
Right, Mr. Penso. So, yes. Does this situation really expose any gaps or ambiguities in our constitution regarding this tenure and responsibilities of MPs? Should we be considering constitutional or electoral reforms to address such legal conundrums in the future? Should we be looking at a reform?
Electoral reforms have not come in. The real issue is the true interpretation of what we have in our constitution. I remember your guest or your host, your co-host, reading over G and H. And let me put it this way, if I have time to go through what he read over, if he leaves the party of which was a member of the time of his election to parliament to join another party, this has not happened in the sense that, or seeks to remain in parliament as an independent member. Nobody has, left his party to join another party during the term of this parliament in the sense that the intention to create that relationship is in the term of the parliament to come. Indeed, the surest way of a person leaving his party is by resigning. That's the surest way. What is rather happening is that people are putting an interpretation on the intention that has been declared to seek an office or seek parliamentary seat in the next parliament.
You are expressing your idea or your thinking or your reflection of 97(1)(g) and H. But you just said something. I just want to take you back to it. You said, right before we go to Dr. Rashid Rahman, you said that these members of parliament represent constituencies, represent people. Now, I want to ask you, the member of parliament for Fomena, for example, Honorable Esiama, became MP on the ticket of independent candidacy. The people who voted for him voted for him over the MPP's candidate. Now he is going to contest on the ticket of the MPP. Is he still representing those interests?
Naturally. I mean, a representation of people in parliament is to stand in for them, express their views, represent them in all ways. And that code or that political creed or that affiliation that he had with his constituents does not change for the current term. The term of which he took an oath to represent that particular constituency. It does not fade merely because he has declared an intention in the next parliament to join a political party.
Okay, right.
He still owes an obligation to his constituents on the ticket or on the terms on which he came to parliament.
All right. Thank you for that quick answer. Let me bring in Dr. Rashid Rahman of the Africa Center for Parliamentary Affairs. Dr. Rahman, thank you for joining the conversation. I'm sure you've heard of a lot of what the other guests have said on 97(1)(g) and H. What is your proper interpretation of these two clauses of 97(1)?
Thank you very much, and a good morning to everyone. Let me start by giving a caveat. I'm not a lawyer, and I'm hearing lawyers, giving all kinds of interpretations to, these constitutional provisions. Yesterday, when I was following the debate in Parliament, there was one particular submission that really, brought home all these arguments to me. And that was a submission made by Honorable Dafiameko when he was making reference to, I think, H or one of the constitutional provisions.
Right.
And this was in relation to Right Honorable Dua Jaho, where the Constitution says if a member of Parliament is elected to the high office of the Speaker of Parliament, automatically he or she ceases to be a member of Parliament, and therefore a by-election is triggered. So his argument was anchored on the automaticity of some of these provisions. And so for me, I think that drew this whole thing home. Look, I think we are stretching these arguments too much. And I've heard lawyers who have faulted Right Honorable Michael Kwe for the ruling that he made exactly about 4 years ago. And yesterday, I think in the final words of the Right Honorable Speaker, again, he said, don't do unto others what you don't want others to do unto you. And I thought that was a very telling kind of, remark from the Right Honorable Speaker. So for me, from where I sit and watching Parliament and having followed all these things over the years, what is worrying for me, Benjamin, is the fact that I think we've seen so many forays of the courts into parliamentary space. If we are not careful, we are setting Parliament for inefficiency. We are setting Parliament for ineffectiveness, because look, in the 9th Parliament, depending on who is who holds the majority, we might see some of these things used as precedents. If somebody is not happy with anything that is happening in Parliament, he or she will run to court. And then, even before, in this instance, even before the Right Honorable Speaker has given a ruling, we are seeing injunctions and so on. So for me, I think that is a worrying part. That is a worrying part. If we are not careful, we are opening up Parliament for excessive interference by other branches of government.
Dr. Draman,
currently, yes.
and that's a point that Cletus Avoka makes, that we may end up fettering Parliament by maybe even having this fetish for going to the apex court. There's also been talk about the fact that I heard one of them say what happens in Parliament is a closed book. So it appears they are opening themselves consistently for the judiciary to now say, okay, this is the way to go. Though technically you know that in the end, if there are problems of this nature, the apex court will decide. But based on precedents, if we are to look at merely precedents, does this paint a hypocritical picture on the part of the majority? Different strokes for different folks?
Yes, indeed. So I think let me go to the point you made first before I come to this. You know, judicial reviews are normal in democracies. I mean, if a decision of Parliament infringes on any constitutional provision, I mean, the law courts come in. We see that happen, I mean, in advanced democracies, you know. But in this particular case, I mean, there hasn't even been a decision yet from Parliament. The Speaker hasn't made a ruling. And then we are seeing this. And then secondly, I think in terms of, you know, the standards, we have to make sure that there is a dictum in parliamentary development which says that minorities change. And in fact, there is a famous US senator, I think in his last statement on the floor, a very famous senator from Hawaii, Senator Inouye, he's famously quoted as having said that minorities change, and whatever you do, just make sure that when one day you find yourself on the minority side, you can live with, you know, whatever policies or whatever laws that you are trying to push down the throat of the minority. And I think that this is a classic case of that kind of situation. I mean, if 4 years ago we said that, and indeed it was even the party at the time that wrote to the Speaker, and our constitution hasn't changed, Benjamin. We are still dealing with the same constitution.
Right.
So what is different here in this particular instance? I think we have to be clear. It's about balance of power. We understand that.
Right. Dr. Rahman.
So maybe yes, let me land.
Yeah.
Maybe, I mean, let the parties that are aggrieved come on some other different and maybe stronger arguments. But if they rely on this constitutional provision, I guess there are a lot of questions that have been left unanswered.
Just a quick one before Sweetie comes in. So you're saying that from where you sit, what the minority is calling for is the right thing? Just a straightforward answer.
Yes, because I think I mentioned what I heard yesterday from Dafiameko, which really drove this home to me. And then if we tie this to the precedents that has been set by Right Honorable Speaker Okwe, maybe unless somebody says that we are not reading this English quite well. And if so, then like you rightly said, this constitutional provision is a candidate for a constitutional review whenever we get a chance to review our constitution, so that, I mean, the rendition is made as clear as it can be, because I think in these matters, we don't want any ambiguities.
Right.
Otherwise, we might face similar situations in the future. We are going to see parties haven't learned their lessons. We are going to have the same situation maybe 4 years down the road, where some candidates might be aggrieved and decide to either go independent or do whatever they think might improve their electoral fortunes. And then we will be back to this same conversation.
Dr. Drama, you spoke about balance and the excessive interference by the courts in parliamentary businesses. So in this case, where do we draw the balance? Can Parliament independently deal with this matter, considering that the Supreme Court has been brought into it? And what are the possible legal and political solutions to navigate this conundrum as we speak? How do we move forward?
Think that, yes, for me, I think the leaders of Parliament have to reflect carefully on this. Because like I said, I mean, we might wake up in the 9th Parliament and the balance will be different. And if somebody is not happy with any little thing that is happening in the House, they will run to the court. I mean, we don't want that. We don't want Parliament to be, in a position where it cannot do its constitutional duties. Benjamin spoke about the fact that, whatever happens in Parliament is a closed book. Honorable Muntaka Mubarak has been, talking about this almost every moment when he gets a chance, and there are issues related to the interference of the judiciary in the work of Parliament.
So in your opinion?
He says, yes. So before the 8th Parliament, most of us thought that whatever happened in Parliament was a closed book. But, the 8th Parliament has taught us that that is not the case. And I think the leaders must reflect carefully on this. I think for the sake of, the changing nature of minorities in our Parliament.
Right.
So that tomorrow, when somebody is in the minority, they don't come crying wolf and saying this is not fair because a precedent is being set.
So the Speaker has asked for 2 days to think on this and rule. Should he wait for the Supreme Court before he makes a decision? In your opinion, in terms of the way forward, should the Speaker wait for the Supreme Court or just go ahead and independently, as Parliament, deal with this?
No, I don't think that the Speaker should wait for the Supreme Court. In my honest opinion, Parliament is doing its work. Let the court wait and let the Speaker make his ruling. Let somebody say this is, over the years, what I have always told Parliament is that, we have interpreted the powers that are given to Parliament by the Constitution and by the standing orders to the extent that, most of the time, Parliament takes the lesser part of those powers, i.e., when Right Honorable Speaker Okwe said in the matter of the private members' bill, Speaker after Speaker tried and people said, no, this is an infringement on the Constitution because it's going to impose a cost on the consolidated fund and so on. And at the time, I think that the conversation was, let's do this and let somebody go to the court and tell us that, we are punching above our weight and we are taking powers that we do not have. And today, the private members' bill regime has come to stay in our Parliament.
Right.
I think it's the same thing here. Let Parliament exercise its powers as provided for by the Constitution, and then afterwards, let's hear from the courts. So I think the Right Honorable Speaker should go ahead and make his ruling.
All right. Thank you
maybe
so much.
As you deliver your final comments, gentlemen, another thing that has been on my mind, is it premature? Because the Speaker hasn't even ruled yet and the Majority Leader is in Parliament. Some people have said, let him rule, and if he rules in that way, then you can go to the apex court. I don't know what you think, but I can start with you again, Dr. Draman, with your final thoughts. Final thoughts for everybody, and it's a wrap. In some 40 seconds maximum for each person. Dr. Draman.
Yes, so let the Speaker rule. Let anybody who is not happy with the ruling go to court.
Okay.
So that in that case, at least we are strengthening our democratic practices.
Okay.
And I think, again, Benjamin, let me add, let our leaders in Parliament be careful how quick and how fast they run to the court. This might come back to haunt the institution.
All right. Thank you so much for those brief thoughts. Kweku Painto, final thoughts?
I I disagree with the previous speaker for the reason that Parliament would always, in terms of interpretation of laws, be subservient to the Supreme Court. That is the peculiar constitution that we have formulated for ourselves in Ghana, following, various experiments, beginning from Kwame Nkrumah through Busia, through military regime. So the constitution we have is a peculiar constitution. And what's going on in the country is a reflection of what we intended for ourselves. Everybody is free. Supreme Court will always remain the final arbiter. So whatever the speaker does is the embarrassment that...
Akufo-Addo, we seem to be losing you. For a moment, you say it's the embarrassment of what? I think there's an issue. Whether I don't know what it is, but we have a sound issue with Akufo-Addo. I really would have wanted to hear what he said about this embarrassment or something. Let me take Dr. John Osai-Kwapong, and then maybe I'll come back to Akufo-Addo. I find it interesting. Professor Aaron Michael Quay did something that became precedent, but now it no longer makes sense. I don't know. Final words, Dr. John Osai-Kwapong.
Well, I share the sentiments and the thoughts expressed by Dr. Rashid Rahman in the sense of, one, let the speaker rule, and if you feel aggrieved, seek some judicial review of that. But at the same time, though, I hope that Parliament as an institution would be a little slow in drawing the courts into a lot of their disputes. Because you see, sometimes when you go to court, depending on the court of the depending on the ruling of the court, you set a precedent where sometimes you can even make, quote unquote, a bad situation worse. And I've always said that if there are things that you can resolve by conventions or by administrative practices, try to do that a lot of the time before running to the court to seek judicial intervention.
Doc, we're grateful for your time. And we're fortunate enough to have Peter Yaokwache Aka also joining the conversation, a Memphis Central legislator. A very good morning to you, sir.
Good morning, sir.
It's good to have you. Now, you ran on the ticket of the NDC in 2020, and things have changed for you. You are also going to be affected by this entire call in Parliament. How do you feel about it, for starters?
Well, to every action, there's a reaction. So if you take some action, you must expect some reaction, or nobody will just sit down there and allow you to go through. So that is politics for you. So I'm ready to face whatever comes.
Are you happy with this reaction, especially as it's coming from your side in Parliament?
Oh, well, I don't have any problem with that. If that is the truth, why not? They should go ahead because this is not the first time. As you spoke to this, maybe constitutional lawyers, they can interpret it better. I'm not a lawyer. I'm an engineer. But I feel that there's a precedent, yes. So we can't argue much. There's a precedent. When the former MP went independent, I think Professor Michael Quay ruled that he was not a member of the party. So maybe we don't know what this present speaker is going to say. He's an experienced person. He knows what to do. And I think he would use his own money to rule. If he follows the vision of Professor Michael Quay, so be it. If he says that, well, as other lawyers, constitutional lawyers have said that, well, this clause was put there to prevent cross-carpeting, so that if you are in one party, the next day, you cannot get out and say that you are moving to the other side, to the other party. But this, in our case, we have that intention that the next politics will not be joining again. So a law is two-sided. So we wait for what will come out because we are still with I'm still the NDC. If it's going to vote on the appeals, going to vote for the NDC. But maybe the next parliament, then I'll decide where to go because I'll be an independent candidate. But not in this parliament. People can interpret that way. But no, now I say I'm still with the party. I've not declared any intention to leave the party. I've not declared to leave the parliament. So that's also say that as far as I've left gone to the independence, you cease to be a member of the parliament. So whatever comes, we will accept it.
Okay, so just very briefly, you don't have any problem with this, and do you think it is hypocritical for the majority now to be saying that, we should seek some clarification from the Supreme Court?
That is the funny side of politics. Yes, those agreeing this side, the next side will feel like it. So there's no one now because but earlier, I think when MP went, they were supporting the speaker on the other side. Maybe they say it's only the food that doesn't speak his mind. So let's see the whole honor in the hands of the speaker. So he's an experienced man. He trusts his judgment. He is the most experienced legislator in the country as now.
All right.
So I think to use his own interpretation to give ruling. And whatever comes, I think all of us will have to abide by it.
Thank you so much, Peter Yakwachiaka. He's Member of Parliament for Minfi Central. But we have to give the final word to Roxy Nelson Dapemokbo, and then we are off. Mr. Dapemokbo. Okay, he's gone. So that's that for this belt of conversation. Benjamin, interesting times. Balance between...
Kwachiaka just said that is the funny side of politics.
Yeah, but
He's personally affected, and he says that's the funny side of politics.
It is majorities, it is theirs to use, because the minority wants to use it against them. It's just the politics.
Someone will also say when the NDC was in power and some of these, or the NDC was in opposition under the speakership of Aaron Michael Quay, they could have also run to the Supreme Court. They decided not to. But some would also say, no, precedent stakes, and we were just adhering to the processes.
But I lean towards the caution of we should be careful in interference from the courts in Parliament. Otherwise, we're taking away the independence of these institutions. But folks, we have to go. There's a lot more coming your way on the AM show. Don't go away. We'll be right back.